Welcome to Discovering the Law. My name is Lucy Rivera and I will be your host. This episode can be viewed at www.discoveringthelaw.com. And today we have a very special guest. We have the Chief Judge from the Massachusetts Federal Court, Bill Young. Your Honor, thank you for coming today.
Remember, I was the Chief Judge.
Oh,
I'm not the Chief Judge now, because I've been a judge for quite some time, but thank you for having me.
Well, Your Honor, thank you for coming. And yes, that's right, it's Honorable Patty Saris. She's
Correct.
the current judge. And how long were you the Chief Justice of the Federal Court?
The Chief Judge is, for 7 years, I was the Chief Judge, and it goes by seniority. So I've had my turn, and now Chief Judge Saris is our chief, and she's a wonderful chief.
Your Honor, on those 7 years, you must have heard amazing cases. Would you like to talk about some of those interesting cases you worked on?
The cases, and it's important to understand this, the judge does not choose the cases. The cases are assigned randomly. So all the judges get all the different types of cases. Now, it has nothing to do with my being chief judge for that's an administrative job, but I've been a state judge. They call state judges justices. So I was a justice of the Massachusetts Superior Court for 8 years, and now I'm in my 31st year as a judge of the Federal District Court. So your question is, have I had notorious cases? I have, but that's just random as they were assigned.
In your career?
Yeah, that's right. I've had the case that they later made into the movie The Accused, about a rape in the Big Dan's bar in New Bedford. I've had, as a federal judge, the shoe bomber who attempted to blow up the plane with a bomb in his shoe. As a state judge, I had the case that approved Proposition 2.5. As a United States judge, I had the sad case of the victims of Whitey Bulger when they were suing for compensation. So those are some of the cases that have been, I would say, notorious cases. And
would you like to talk a little more in depth as to some of them? Which ones would you prefer to?
Well, what you learn, really, is how wonderfully fair the jury is. Go back, what they call the Big Dan's rape case. That case was tried back in 1983. Now, that was one of the very first cases that they televised, and they televised it gavel to gavel. Imagine, and there was a great deal of public interest. The case was tried before two separate juries because you had to give people a fair trial, you had to have two trials. Imagine those jurors who took the time and fairly and impartially decided that case. That was an extraordinary burden. And what you learn is, you learn just how fair citizens are, normal citizens. They are so wonderful, and they have such a sense of both duty and a sense of decency and common sense. If there's one takeaway from all of these cases, it's the great joy and privilege to work with American citizens.
Your Honor, and that also actually begs the question, most countries do not use the jury system. In fact, there is one jurisdiction in the United States that does not use that system. Why are civil juries important?
Well, you have to understand that juries are part of our democracy. It's very important to think of what juries are. Juries are a form of direct democracy, the people themselves ruling directly. 90% of the jury trials on the planet take place right here in the United States of America. No country has ever tried to govern with juries to the extent that we have in the United States. And in fact, juries are the great guarantor of our democracy. Jefferson said, the jury is the greatest anchor ever devised by humankind to hold a government to the principles of its constitution. Now that's true. So think about it. There are only 6 types of constitutional officers in the whole United States, only 6. And each branch of government gets 2. The legislative branch, the Congress, they have senators and they have representatives. The executive branch that enforces the law, they have 2. We have a very strong chief executive, President of the United States. This is a presidential election year. Given the frailties of the human condition, we have a vice president of the United States. Now, so now we're up to 4. Now, then in the judiciary, there are 2 types of constitutional officers. There are judges, that they're written in the Constitution. I'm humbly proud to be one. But then right in the Constitution, it says this. You don't need the Bill of Rights for this. This is in the organization of government. It says, the trial of all crimes, save for impeachment, shall be by jury. So jurors are constitutional officers. They do something in our system of government that nobody else can do. I can't do it. In a criminal case, I am not the one who decides. I'm the teacher of the law. Now, the jurors don't make up the law. That the Congress does that. I tell jurors, look, if you want to make up the law, run for Congress. That's not what we do here. But jurors are the ones who decide the facts, decide what's proved, what's actually established. No one else can do that. The President of the United States can't do that. Now, you asked me about civil juries. So criminal cases, that's when the government brings a charge against someone. That someone is innocent until a jury, 12 people, unanimously decide that the government has proved that they're guilty beyond a reasonable doubt. Now, there's countries that decide civil disputes without juries, but not this country. This country gives people the right in all types of cases where money is at issue and many other types of cases. We use juries more than any other country in the history of the world. Now, the 7th Amendment to the Bill of Rights, I'll just paraphrase it, it says all those cases, the types of cases we were trying to juries in 1787, we're always going to try them to juries. So when you think of what juries are, they are constitutional officers. They're my equal. They're the equal of a senator or a representative, president of the United States. And jurors have individual rights, constitutional rights as jurors. In essence, they make our government function. As our government is set up, we could hardly exist without jurors.
Your Honor, thank you. Your Honor, critics of the jury system have said that jurors are unpredictable or that jurors don't understand the law, or why is there the need of a jury system in a civil, maybe trial or criminal trial, where the judge could decide from the evidence?
Let's take the last first.
Yes.
12 heads are better than one. The array of human experience that we have on the jury is better than any judge, and any judge would tell you that. They have the innate decency and common sense. Now, it is said in some rare cases that jurors get it wrong. Judges will tell you that's extraordinarily rare. And from my experience, it's when the system has broken down, and it's not just the judge, but candidly, when the judge has not properly taught the law. Let me tell you a story, and I'll tell you how much I believe in this, because when people say jurors can't do it. April 15th, 2013, I was in my chambers. We didn't have jurors that day. That's Patriots' Day, state holiday, but not a federal holiday. I was at work. So we didn't have jurors. That's Marathon Day. So you remember what happened. And like you, and like millions of people, I watched those videos over and over again. And what I watched was people run into the smoke after the second bomb went off, when they knew it was no mistake, when they knew it was no accident, ripping down the barricades to get to those people who were broken and bleeding out. It took 5 minutes in Newtown, Connecticut, for that shooter to murder those children. There wasn't one school teacher who dove out the window or ran out the doors. They put their bodies in front of the children they were there to protect. Now think of 9/11. Everybody who could get out of the World Trade Center got out. Hundreds of firefighters rushed in because that was their duty. Now on the 16th of April, it's the function of our court. I'm the one who greets the jurors. So I went down to greet the jurors because that was the first federal workday that week. And there they were, teachers, firefighters, ordinary Americans there to serve on juries. And it struck me, no one is going to tell me that those people are not capable of governing themselves. Every single jury trial is both a celebration and a test of whether a free people can govern themselves. They can.
Your Honor, would you, given the system that we believe in, what would be your recommendation, or is there any room for improvement?
Of course there is. Of course there is. It's pretty obvious that I'm a great fan of the jury system. That's been my life's professional work. But let's face it, the system is too slow. The system is vastly too expensive. The actual system of trials can be improved in a number of ways, and Massachusetts is a leader on this. For one thing, and I praise the Commonwealth here, we have this one-day, one-trial system. You come, and if you're not don't get a chance to serve, you don't have to serve again for 3 years. We follow that. Massachusetts has no exemptions. Everybody serves. That's the way it should be. And we take, not just from the voter lists, you see, because that tends to favor the engaged and in all candor, the more affluent. We take from the census. The state takes from the census, and they share their lists with us. That's excellent. Other things, these are maybe small things, but they make a difference. We allow the jurors to take notes. We allow the jurors to ask questions. We tell the jurors going in how long a case is going to take so they can arrange their lives. And not the smallest thing in the world, we give them snacks every day.
There are alternatives to the jury, such as arbitration, mediation. However, when it comes to consumer services, there are abuses regarding arbitration. Would you care to comment on some of these
Well,
Cool.
first of all, and that's a very good question, not every dispute has to go to a jury. It's a right. You can decide to get your dispute resolved in another way. We run, in our court, we run a mediation program to see if people can't get together and resolve their disputes, because every trial does take time, and yes, there is expense, even though you're trying to keep all the costs down. The arbitration with people who decide that they want to arbitrate has value. I'm not one to say that arbitration doesn't have value. Arbitration has value. What I will candidly tell you, I think we have gotten off the track, is where large companies can, in essence, force people to engage in arbitration in order to just have a service, to have cell phone service, for example, to trade on the stock exchange, to do any one of a number of consumer actions that all of us do. And this is a consumer issue. People should be alert to this, that they are giving away their rights, really, their rights to the protection of those statutes which only juries can vindicate. And it's not just me that's saying this. The distinguished arbitration agencies, the American Arbitration Association, they won't do consumer arbitration because it's so unfair. It's known to be unfair. And while the Supreme Court, which favors arbitration, and one can understand that, has said that arbitrators are a way substantially to vindicate the statutory goals that Congress has passed, if you look at the actual statistics, it's not. People don't bring consumer arbitrations because there's just no way that they can stand the costs and the risks. So all these statutes that Congress has passed, in essence, those companies that use arbitration, and this is a calculated thing, they're using arbitration to avoid having to face up to their obligations, which otherwise they would have to face up to in court.
Our guest today is former Chief Judge of Massachusetts Federal Court, Bill Young. Your Honor, it's really interesting what you're saying. I'm not sure if there is a perception out there of unfairness by these forced arbitration clauses that most of us are not aware of.
Well, I don't know that I can speak to that. Certainly the people who have written about it, the scholars, but many journalists, this is a live issue as to whether this is appropriate in our society. And it's not that it's unconstitutional. Large businesses have decided that this is an appropriate way to largely eliminate consumers from actually seeking redress for wrongdoing and the checks of the civil justice system. If that were to change, it will have to be the people who change it. It will have to be ultimately the people's elected representatives. That's not for me to say. Understand, my concern is with forced arbitration. If people have a dispute and they get into a dispute over the building of a house or something like that, and they decide they want to arbitrate, that's fine. There's nothing the matter with that. Arbitrators would argue to you, well, that's faster than the courts. Arbitrators would argue to you it's less expensive than the courts. And I would admit, in some circumstances that's true, though all the statistics show that if you have 3 arbitrators, it's as slow and as expensive as the court system. But I recognize that bargained for arbitration, I'm fine with that. I take that as a competitive way to resolve a dispute. I'm just working as hard as I can to keep the delay and the costs of our national court system down, so everybody gets a fair shot, and they get a fair shot before a jury of the people.
Your Honor, you indicated at the beginning of your interview that it's a constitutional right of everybody. You have a constitutional right to a jury. It's been in the Constitution. However, the Supreme Judicial Court came down with taking away that constitutional right from the people by this clause that you're talking about, forced
Well, it's not,
arbitration.
it would be wrong for me to say that the Supreme Court has taken away a constitutional right. Under our system, the 9 members of the Supreme Court have the last word on what is constitutional. I am sworn to follow that. And I did not say they have taken away a constitutional right. I do say that with respect to forced arbitration, they have not yet realized how forced arbitration has really eviscerated, has undercut all those statutory rights that Congress has conferred on the American people. Now, I would hope for change, but I am sworn to follow the decisions of the Supreme Court, and I follow them faithfully. That does not prevent me from saying that I disagree with respect to forced arbitration, and I do.
Thank you, Your Honor. We do have just 2 minutes left, but I would like to hear your thoughts about judges and whether they should be appointed or elected, and what is the
Well, I think the question is, what do you think a judge is? A judge is nothing more nor less than society's law teachers. That's what your judges are, whether they are on the Supreme Court or whether, like me, they are a trial judge teaching juries and deciding individual disputes. Now, we don't elect our teachers. We elect our school committees. We elect mayors. So it's like we elect those people that set the curriculum, and we should. We elect the Congress. But my job is to make the laws that Congress pass live. That's a teacher's job. I don't think the best way to do that is by election.
However, Your Honor, there are jurisdictions in the United States, such as Florida, that do have judges elected. And those jurisdictions seem comfortable with the notion that judges can be elected by asking for favor and yet dispensing independence in their...
Well, the way you frame the question, I'm not so sure they're comfortable with it. But historically, you see, historically, the reason for that is that we do believe in representative democracy. We do believe in electing our leaders, and in many states, judges are elected. And life goes on, and I'm not saying those judges are not professional and do not try terribly hard. I do say that a better system is the system found here in the Commonwealth of Massachusetts and in the United States.
Because it dispenses...
Because it makes you truly independent. Truly independent. I have very, very nice chambers. I sit in the federal court right on the harbor. And I say to my law clerks, because they have nice offices in my chambers, and I say to them, you know, the people gave us this. These aren't ours. And we're here for only one reason. The reason you have this nice office, the reason we are here, only one reason. And what it is a prayer. It's a secular prayer, completely secular. And this is it, that we get it right. That's all I ask, that we get it right, that we are absolutely fair, fair to the government, but fair to the least of the individuals, fair to the big company, absolutely fair, but fair to the one who doesn't have any money, absolutely fair according to the law.
Would somebody who, with a judge who received a large contribution from a corporation, be able to exercise the same kind of independence?
Well, there are ethical limits on judges, and a judge could recuse herself and say, I won't sit on that case. It's not for me to judge other judges. Those issues are inherent in the problem of electing judges.
Your Honor, we have been really grateful that you were able to join us today. Unfortunately, we have run out of time. And for our viewers today, this is Massachusetts Federal former Chief Judge Bill Young. And my name is Lucy Rivera, and I was your host today. This episode can be viewed at www.discoveringthelaw.com. Thank you for watching today.